So, it's 2026, and you know what? The debate is over. We're no longer asking if lawyers should be using AI. That ship has sailed. The only question that matters now is how you're going to use these incredibly powerful tools ethically, how you're going to protect your license, your clients, and frankly, your entire reputation. So today, we're going to break down the bar's new mandate on generative AI. We'll be focusing on these core pillars of compliance that every single attorney absolutely must master.
All right, let's just dive right in. We're in a brand new reality where AI isn't just some shiny new toy, it's become a fundamental piece of the legal ecosystem. I mean, think about it. Even the next-gen bar exam now tests a lawyer's ability to spot the flaws in machine-generated logic. The frontier is officially here, and navigating it, well, that requires a whole new ethical playbook.
And the scale of this change is just staggering. A recent Clio Legal Trends report found that 79%, that's nearly 4 out of 5 legal professionals, are already using AI tools. This isn't some niche tech for early adopters anymore. It's gone completely mainstream. And that is precisely why having clear, enforceable ethical rules has become so absolutely critical. This explosion in use leads us straight to the very first core mandate: competence. Look, the bar has made it crystal clear. Technological literacy is no longer some nice-to-have skill on your resume. It is a fundamental, non-negotiable part of the job. And the heart of this whole thing is the update to Model Rule 1.1. Your duty of competence now explicitly, in black and white, includes understanding the technology you use. You can no longer just shrug and say, "I don't know how the AI works." That's not a defense anymore. It's a direct violation of your professional duty. Now, does this mean you need to become an AI engineer overnight? Of course not. But it does mean you are required to have a solid working understanding of your tools. You have to know the answers to these questions. Can this thing just make up case law? Does it send my client's confidential data to a public server? You've got to know this before you even think about using it on a client's case.
Okay, next up, supervision. And this one gets right to the very heart of what it means to be a lawyer. Here's the bottom line. Accountability can never, ever be outsourced to a machine. You are the sovereign of your work product. That responsibility is absolute. The buck stops with you.
This quote just nails the bar's position perfectly. Think of your AI as the most brilliant, fastest, most tireless paralegal or clerk you've ever had. It can do amazing work, but just like any human on your team, its work requires your final expert review. The judgment, the strategy, the ultimate call, that all remains yours, and yours alone. And under the updated rules 5.1 and 5.3, this human-in-the-loop protocol isn't just a good idea, it's mandated. Your supervisory duties now officially extend to, and I quote, non-human autonomous systems. That means every single thing it generates, every citation, every argument has to be independently verified. We're talking a complete review from scratch before it goes out the door. Let's be perfectly clear about this. In the eyes of the bar, in the eyes of the court, that's your signature on the motion. So the liability for any mistake, any fabricated case, any faulty logic, well, that's all yours too. Delegating that final check to an algorithm isn't just being a little bit risky, it's malpractice. Period. And this chain of responsibility flows directly into our next pillar, that sacred duty of confidentiality, all governed by Rule 1.6. In this new world of cloud-based AI, honestly, protecting client information has become one of the trickiest ethical minefields we have to navigate.
The guidance here could not be more clear. If you take sensitive client information and feed it into a public AI that uses that data for its own training, you've just committed a cardinal sin of legal ethics. Just try to imagine explaining to your client that their top secret merger strategy is now part of a global data set. That is a career-ending conversation. The only safe, compliant path forward is using secure, private AI instances with zero retention policies. There is no other way.
Okay, so we've got the core principles down: competence, supervision, and confidentiality. But what does all this theory actually look like in practice? Let's take a look at the specific guidance that's starting to come out from bar associations all across the country. As you can see, a really clear national consensus is taking shape. We're talking over 35 state bar associations have already issued formal guidance, from Florida to California. And while the fine print might differ a little bit here and there, the core message is identical everywhere. You must prioritize confidentiality, you must verify all outputs, and you must maintain absolute human oversight. So to meet these mandates, the firms that are really getting this right, the ones who are succeeding ethically, they're not just buying software off the shelf. No, they are building a completely new kind of ethical infrastructure. They're taking concrete steps like these to weave compliance right into their daily workflows, turning these principles from ideas on a slide into operational reality.
When you get right down to it, adopting AI is not a license to delegate your judgment. It's actually the opposite. It's a profound call to reaffirm that legal advice is and must always be a fundamentally human act, one that's grounded in reason, in loyalty, and in integrity. The technology is an amazing clerk, but you remain the Sovereign Counsel. So the only real question left is, how are you going to wield that power?
All right, welcome back. In this final part, we're shifting gears from the what of AI ethics to the really critical how. We're going to break down exactly how you can protect your practice and, more importantly, build your career on a rock-solid foundation of digital integrity. So let's start with the single most important point right out of the gate. As of today, saying the AI made a mistake is not going to save you. In fact, it's a direct confession of what the bar is now calling algorithmic negligence, and it will lead straight to sanctions. The window for claiming you didn't know? Yeah, that's officially slammed shut. The real ghost in the machine we have to confront is something called legal hallucination. Now, this isn't just a simple glitch. This is the AI creating what's known as synthetic precedent, stuff that sounds plausible, looks right, but is completely made up. And make no mistake, if you rely on this, it's now seen as a fundamental failure of your basic competence as a lawyer. Now, you might be thinking this is some rare, weird edge case, right? But the scale of this problem is absolutely staggering. A 2024 study found that these legal hallucinations can pop up in up to 88% of outputs from some of the most popular models out there. That's not a bug you can just patch. It's a core feature of the technology you have to actively manage. And that really highlights a fundamental truth about what we do. Accuracy isn't just a nice to have. It is the currency of the courtroom. And if that currency is counterfeit, if your citations are completely fabricated, the result is a total loss of credibility. Your career could literally be over. So, this brings us to the solution, something called grounded retrieval. The bar now pretty much requires a workflow that separates verified precedent, the stuff you get from Westlaw and LexisNexis, from this dangerously unreliable synthetic precedent the AI just dreams up. Your professional duty now is to know the difference, and you have to be able to prove it. Okay, so how in the world do we navigate all of this? Thankfully, we're not flying blind. The American Bar Association has given us a really clear framework to guide us through it. Back in July 2024, the ABA released Formal Opinion 512. Now, what's interesting is it doesn't invent a bunch of new rules. Instead, it just maps our existing model rules directly onto the challenges that AI brings up. And it all boils down to 6 essential pillars. First up, competence. Now, this doesn't mean you have to go out and become a software engineer. What it does mean is you need to have a reasonable understanding of the AI tools you're using, what they're good at, what their limits are, and crucially, their known ways of failing, like that tendency to hallucinate. Second, confidentiality. And listen, this is a big one. Rule 1.6 is completely non-negotiable. If you input sensitive client information into a public AI model that doesn't have a contractual guarantee of data isolation and a zero retention policy, you're almost certainly breaching your core duty. It really is that simple. And third, candor toward the tribunal. The lesson from cases like Mata v. Avianca couldn't be clearer. The lawyer who signs the brief is the absolute guarantor of its accuracy. It doesn't matter if an AI wrote it, if a junior associate wrote it, or if you wrote it yourself. If your name is on it, you own it, period. And you know, these duties don't just stop with you as an individual practitioner. They scale all the way up, creating a direct mandate for every single supervisor and managing partner in a firm. There is a really startling disconnect happening right now. Just look at the data from the Clio Legal Trends report. It shows this massive gap between AI adoption and actual oversight. So while nearly 80% of legal professionals are using AI, a shocking 44% of their firms have zero formal policies to govern it. I mean, that is a huge, unmitigated risk. This governance gap puts managing partners directly in the crosshairs. Under Model Rules 5.1 and 5.3, they have a duty to establish firm-wide policies, provide training, and implement supervision. The goal is simple: catch these AI-driven errors long before they can ever become ethical violations. So the crucial point here isn't just about dodging sanctions. It's about proactively building a defensible, modern practice that actually earns client trust in this brand new era. Honestly, the best way to think about this is to see it as constructing a fortress of integrity. And that's not just a cool metaphor, it's an actual operational blueprint, a structure you design to protect yourself, your firm, and most importantly, your clients from the risks of this tech. The first pillar, these are the very walls of your fortress, is supervision. Clear, firm-wide policies are not optional anymore. They have to define which tools are approved and lay out precisely how they must be used and verified. The second pillar is confidentiality. Think of this as the gatehouse of your fortress. Your client's trust is your most valuable capital. You have to safeguard it by only using tools that contractually guarantee data privacy, security, and a strict zero retention policy. And the third, absolutely non-negotiable pillar is verification. This is the watchtower of your fortress. You, the human lawyer, must always remain the final arbiter of truth. Every single assertion, every reference, every citation that comes out of an AI has to be independently verified against primary sources, no exceptions. At the end of the day, the lawyers who are going to thrive in this new world won't be the ones who avoid AI. They're going to be the proactive 1% who master it within these clear ethical guardrails. They're the ones who transform compliance from a reactive chore into a core operational advantage. So here it is, the ultimate takeaway. The foundational principles of our profession, competence, confidentiality, candor, none of that has changed. The technology has. So the only real question left is, has your practice?